Your Honor, a mere statement that the police have a blue code of silence is not factual. It is a statement made to hoodwink the court. The applicant IPOA is seeking 21 days to detain the respondent in a police station, not manned by IPOA staff, manned by the same police officers. At one hand, IPOA is confident with the police that remand him in police station. In the other hand, it is telling you, Your Honor, the police have a blue code of silence. You can't speak from both sides. Your Honor, this country, as citizens of this country, every government entity operates within its mandate. We urge the court to find that there are no compelling reasons. Your Honor, the Judiciary Handbook on bail and bond, which the court is very aware, has provided for parameters to be considered for denial for bail. None has been presented before you. The applicant says there is a public uproar. There are demonstrations on the streets. This matter has gone to the Senate. It has gone to the National Assembly, and the Commander-in-Chief of the Armed Forces, His Excellency President Dr. William Ruto, has talked about it. It is our submissions that out of that, this is a knee-jerk reaction to show everybody and the people are talking that we have arrested somebody. Your Honor, may you get favor in my submissions and allow the advocates with me to deal with the law and the authorities that will be supplying to court. I hope the state has been given those authorities. Thank you.
Anybody else?
Yes, Your Honor.
What's the name?
Stanley Kinyanjui. Yes, Your Honor. Yes, and Your Honor, I associate myself with the submissions of my senior, Mr. Danstan Omar. And I begin by saying, Your Honor, that there can never be public interest greater than a constitutional value. That being said, Your Honor, the application for bail is grounded on two principal instruments which is one, the Constitution of Kenya, and two, the bail and bond policy guidelines. Now, Your Honor will note that these two principal instruments then give birth to two foundational values upon which the application for bail has been made today. The first foundational value, Your Honor, is the presumption of innocence. And the second, Your Honor, is the fundamental right to liberty. And paragraph 3.1 of the bail and policy guidelines offer an explanation as to the second value, and goes on to tell us that pretrial detention, such as the one that this court is being invited to make, should be the last resort. And the criminal justice institutions, which is this honorable court, should make every reasonable attempt to avoid subjecting a suspect to pretrial detention. You know, having laid those values, then we must remind ourselves that the bail and bond policy guidelines are guided by principles derived from international instruments. Instruments and practices, Your Honor. And I say that, noting that there is nowhere that politics of the day inform bail and bond policy guidelines. And one such instrument, Your Honor, footnoted at footnote number 20, is the African Union draft guidelines on the use and conditions of police custody and pretrial detention in Africa discussion document of February 2013. And then the Honor will note that at that time, these guidelines were not yet adopted, but were later adopted in what became to be known as the Luanda Guidelines of 2014. And Your Honor, those guidelines identify three questions. Leading to a determination of an order of pretrial detention, whether in the negative or the positive. And one cannot help, Your Honor, but notice the correlation between those three fundamental questions with the fundamental values as earlier on stated. And one captured that paragraph 10b of those regulations is the same value, or rather the question of which is the last resort. As my senior has submitted, that this court has the power to give orders and restrictive orders as such to the respondent in this matter from appearing or being seen anywhere near the scene of crime. The second question this court should answer, is whether there are grounds which have been clearly established in law and not motivated by discrimination of any kind. That is paragraph 11 of the Luanda Guidelines. And Your Honor, in this case, I need to stress on the word discrimination. My colleague will submit on the case of Betty Jemutai, and Your Honor will note that the only reason being advanced by the applicants in this case is the fact that the respondent is a police officer. Your Honor, if that is not discrimination, what is? And third, that is the last question this court should consider, are there any reasonable grounds to believe that the suspect has been involved in an offense carrying a custodial sentence, and Your Honor, I stress on the word and, being conjunctively, there is a danger to abscond, commit further serious offenses, or if released, the individual will not be in the interest of justice. Your Honor has had the benefit of hearing the evidence and the testimony of the deponent of the affidavit. Your Honor, there is no tangible evidence that has been submitted before this court other than the mere apprehension that the respondent is likely to interfere with investigations. Your Honor, the deponent has gone on further to remind us, and he does so in his affidavit and the application, that there are already preliminary investigations which have realized some certain facts. Those facts are not within the court's knowledge, and there is not even a single attempt to inform us why, in the application of denying someone liberty, the information gathered is not before this honorable court. Your Honor, those are my humble submissions insofar as the application for bail is concerned.
Okay.
And before, Your Honor, I sit down, I need to further point out to this honorable court that the application